Court. My name is Erin Doolin, and I represent the appellee, the United States of America, in today's case. The Court should affirm the decision made in United States v. Fisher for two reasons. First, Mr. Fisher did interfere with the duties of the flight crew. Second, Mr. Fisher did intimidate members of the flight staff. Interference is when an individual prevents a member of the flight crew from completing their duties. A duty is defined as a course of action required of one by position, and does not need to be essential or related to the safety of the aircraft, as set forth in U.S. v. Pelfrey. In United States v. Pelfrey, Mr. Pelfrey physically shook a flight attendant, and due to these actions, the flight attendant reported that she was unable to complete her duties of completing her mental checklist and assuming her landing position. Now, in Mr. Fisher's case, the defendant ignored the fasten seatbelt sign and approached the cockpit on 3 separate occasions, despite specific and repeated requests by the co-pilot to remain seated for the safety of the aircraft. Due to Mr. Fisher's repeated questioning, the co-pilot testified that he was unable to complete his duties, such as monitoring the gauges, keeping contact with the air traffic control directors, and monitoring the wind speeds, which was especially vital on this flight because it was a turbulent flight and there were high winds.
Well, Counsel, is that an exhaustive list of all duties, or is it not? I mean, it's my understanding that another duty is communication with passengers such as Mr. Fisher.
Yes, Your Honor, those are the duties that Mr. Fisher interfered with. However, there was a duty to communicate with the passengers. However, the co-pilot had other means to do that, such as the overhead speaker system, which he could use to contact the passengers, Your Honor.
Is there a difference between what Mr. Fisher did and, let's say, for example, another passenger had a heart attack on the plane and the co-pilot had to go out and help since there weren't any other flight attendants? And that could technically be an interference with his duties. Is there a difference between that sort of scenario and what Mr. Fisher did?
Yes, Your Honor. What Mr. Fisher did was ask questions about the flight length and his baggage. There was no immediate concern, and it was not an urgent concern. He repeatedly ignored the fasten seatbelt sign and the co-pilot's directions without any sort of urgent need, Your Honors. Now, while Mr. Fisher did not engage in any physical or violent act like Mr. Pelfrey did, the result in both cases were the same. Due to the defendant's actions, the flight staff were unable to complete their duties.
So let's say I agree with you about, or we collectively agree with you about that. Interference in and of itself doesn't warrant a criminal conviction. It must be coupled with intimidation. So how did Mr. Fisher intimidate the flight crew here?
Yes, Your Honor. Mr. Fisher repeatedly went up to the cockpit, ignoring the fasten seatbelt sign and ignoring specific directions from the co-pilot to remain seated for the safety of the aircraft. The first time that Mr. Fisher approached, he asked about the length of the flight, in which the co-pilot responded and told him he needed to sit down for the safety of the aircraft. The second time Mr. Fisher approached the cockpit, he asked about retrieving his baggage, which was an absurd request because his baggage was being stored underneath the plane, where it was completely inaccessible throughout the entire duration of the flight. To this question, the co-pilot again stressed the need for him to take his seat for the safety of the aircraft. The third time that Mr. Fisher approached the cockpit, he said something along the lines of he would get his baggage himself if instructed to do so. At this point, the co-pilot testified that he was so concerned with the safety of the aircraft that he shouted at Mr. Fisher and told him he needed to sit down for the safety of the aircraft.
But concern and being intimidated are not synonymous terms, correct? I mean, you can be concerned about a situation without feeling fear or being intimidated. Is there something in this record that lends one way or the other as to the co-pilot being intimidated?
Yes, Your Honor. In United States v. Hicks, Mr. Hicks was playing a boombox that interfered with the navigational equipment of the plane, and the court ruled that because it was interfering with the navigational equipment of the plane, this was no doubt intimidating. In United States v. Fisher, the fact that Mr. Fisher was interfering with duties that were essential to the safety of the aircraft, that is, without a doubt, intimidating behavior.
But does what Mr. Fisher did warrant a federal criminal conviction? And some of these other cases, there was physical violence, there was verbal abuse to passengers and it disrupted the entire flight, is simply going up and being nervous and asking about your bags, does that warrant the criminal conviction?
Yes, Your Honor, because he violated safety principles again and again. Now, in United States v. Hicks, it was undisputed that none of the defendants committed assault or battery or verbally threatened any Continental flight crew member with physical harm. In United States v. Hicks, the intimidation resulted solely from the defendant's verbal and nonverbal expressive activity. Therefore, it is not necessary for any sort of physical harm or physical contact to occur. The fact that Mr. Fisher was using loud, aggressive, and persistent behavior and repeatedly ignoring the safety policies of the aircraft was no doubt intimidating. It would be a dangerous precedent to set to allow a passenger on an aircraft to repeatedly ignore safety instructions, especially in light of the events of 9/11. Now, another passenger on the aircraft.
Just briefly before you turn to your next point, Mr. Griffith never testified that he was intimidated or felt threatened.
No, Your Honor, he testified that he felt extremely concerned for the safety of the aircraft. Another passenger and former law enforcement officer, Carter Smith, also felt so concerned for the safety of the flight that he interfered and actually told the defendant that he worked for the police and would force him to sit down if necessary. It is clear that based on the accounts of two different individuals on this plane, that Mr. Fisher's conduct was intimidating. We ask the court to affirm the decision made in United States.
With respect to the passenger, how does, is that relevant to the actual language of the statute, or does it matter whether or not he was intimidated?
It is not legally relevant, Your Honor. I simply bring it up to show that the co-pilot was not simply irritated with the passenger. There was real concern, and that another passenger also felt this concern based on Mr. Fisher's actions. We ask the court to affirm the decision made in United States v. Fisher. Thank you.